conviction and sentencing. So currently he is incarcerated. In fact, I think they took him to Nsawam yesterday. So as we speak, Chairman Wontumi has joined the people in Nsawam and is there. They have been threatening that they'll file an appeal.
Yes.
All these things are not necessary if you plan to.
I think 6th, 7th, and 8th Parliament.
Yes. Oh. She's been in Parliament for a while. Yes, she's been in Parliament for a while. Wow. Yeah. So let's listen to the portions of that press conference that was addressed by the minority and what they had to say.
Some judgments settle a case. Others test a nation. Ghana will be judged in years to come, not by the sentencing handed down in Accra yesterday.
Well, so we'll continue to share that with you, exactly what they said. You see, the way it started, it is problematic.
What's a macacho say? Me penny ni diminano.
Yeah.
Very calm.
Yeah.
On preno. We a press conference near. You know, 30 minutes. You know, I'm going to change. I'm going to 30 minutes.
But I usually think press conferences, like what you read out, should not last more than 50 minutes.
Yes, sir. Point.
Because if you invited us from the press to come and listen to you, my best advice to anybody holding a press conference is that your statement maximum should be 10 minutes.
10 minutes.
Yeah, because you are just there to state your position. Don't come and tell us history. We know the history. Trust us, we do. Yes. So just state your position, and then any questions will be asked. But sometimes you argue. By the time you are done after 1 hour, we just want to go. No. We just people who wanted to ask questions, we just decide no. This thing has taken too long. Yes.
Some judgments settle a case. Others test a nation. Ghana will be judged in years to come, not by the sentencing handed down in Accra yesterday, but by how faithfully we defended our constitution in the aftermath. We speak today on behalf of the minority caucus in response to the judgment convicting the Ashanti Regional Chairman of the New Patriotic Party, Mr. Bernard Mpibu-Esiakun, popularly known as Chairman Wontumi, and Akonta Mining Limited. We speak not as advocates for one man, but as custodians of a constitutional order that must apply equally to every Ghanaian, regardless of political color. The New Patriotic Party has already issued its own statement on this matter, expressing profound disappointment, insisting no evidence showed that Wontumi unlawfully assigned his mineral rights, and calling the conviction a travesty of justice. We do not repeat that statement here. We in the minority, we do not repeat the statement here. And nothing we say duplicates it. We speak instead for our own constitutional duty as the minority in Parliament to interrogate the conduct of the state wherever the public interest demands. Before we turn to the law, the word for the human beings at the center of this, to Chairman Wontumi, to his family, to the New Patriotic Party in the Ashanti region, and to our party at home and abroad. You are not alone. And your pain is a shared one. Grief and anger are natural in a moment like this. The best tribute we can pay Chairman Wontumi right now is a razor. The minority would do whatever is lawfully and properly within its power through Parliament and through public advocacy to see that justice is done, and that the defects which have robbed the judgment of its legitimacy are corrected. Let us be equally clear about where we stand on the law itself. We hold the judiciary of this republic in the highest constitutional regard. We do not impugn Justice Kokubi Tay personally, and we invite no one to disrespect this judgment. We support accountability. We support the vigorous prosecution of illegal mining, a scourge that has degraded our rivers and endangered the livelihoods of generations yet unborn. We seek immunity for no one on the basis of the party. But 4 serious defects run through this case, and each deserves nation's full attention. First, the denial of a counsel of choice. We understand that judgment was delivered despite the absence of Chairman Wontumi's lead counsel, whose office had notified the court of a prior professional engagement abroad. Article 19 of our Constitution guarantees every accused person a lawyer of their own choice, and that guarantee may only be displaced in the most exceptional circumstances. This country once built a decade of political outreach around exactly this question in the trial of Mr. Chachuchi Kata. That case ended in 2016 with the Court of Appeal acquitting Mr. Chikata and condemning the trial's conduct by name as a miscarriage of justice. If that standard mattered in 2016, it matters today, regardless of whose name sits on this charge sheet. Second, the refusal to refer serious constitutional questions to the Supreme Court. Article 130 reserves constitutional interpretation for our highest court alone. Instead, the trial judge decided for herself that Section 99 2B of the Minerals and Mining Act was, in her own words, clear and unambiguous. Our own Supreme Court has already condemned exactly this maneuver. In the Zanato case of 2016, the court quashed a high court ruling for wrongfully assuming jurisdiction over a constitutional question. It ought to have referred. The parallel here is exact, not merely similar, and on that authority alone, this judgment reflects a miscarriage of justice, correctably on appeal. Third, and perhaps most vulnerable of all on the law, is how the court pierced Akunta Mining Limited's corporate veil to convict Chairman Wontumi personally. Since Solomon and Solomon in 1897, a company has been a person in its own right, separate from its shareholders and directors. Our own Supreme Court affirmed exactly the principle in Mokos versus Kuma. Veil piercing is permitted only where a company is a sham, a vehicle for fraud, or built to dodge an existing legal duty. None of that was found here. Akunta Mining was incorporated in 2010. Its lease was granted in 2021. The conduct alleged came later still. There was no obligation yet in existence for the company to dodge. What the court found was untidy governance, not fraud. And untidy governance is no license to erase a company's legal existence. Worse still, the judgment convicted Wontumi and the company separately on separate counts, using reasoning that treats them as one and the same. A court cannot dissolve a company to convict the man and then reassemble it, fully intact, to convict the company too. And all of it was unnecessary. If the evidence showed Wontumi personally directed unlawful mining, ordinary criminal law already covered him as a principal or an accessory without touching the company's separate existence at all. Left uncorrected, this reasoning threatens every founder-led business in Ghana, from the smallest family enterprise to the largest. Fourth, selective justice. In July of last year, the Attorney General directed an investigation into the NDC's own national organizer, Mr. Joseph Yami, and its vice chairman, Mr. Yakubu Abanga, over allegations of illegal mining. Months later, there is no comparable update on charges or trial dates. A sitting government member of parliament has publicly acknowledged overseeing a mining site taken over from its lawful owners with no prosecution to date. And an NDC member of parliament charged over an anti-Galamsey clash was granted bail within days. This pattern, taken together, sustains a reasonable perception that the machinery of the state moves fastest and lands hardest when it is pointed at the political opposition. A government serious about ending selective justice must prosecute its own with the same vigor it has shown here. These four defects matter far beyond this one case. A democracy survives on the confidence of the losing side that the rules of the game are fair. If trial courts may sidestep constitutional referral, deny counsel of choice, and stretch veil piercing beyond recognition whenever it is convenient, then no citizen's rights are secure. Whatever party they belong to, and public trust in institutions that must outlive any single administration is corroded. We therefore call on the Attorney General to publish the state's enforcement record on illegal mining across the political spectrum. We call on the Court of Appeal to scrutinize the denial of counsel, the refusal to refer, and the veil piercing with equal and unflinching rigor. We call on the judiciary to reaffirm the threshold for constitutional referral, with express regard to the Supreme Court's own decision in the Zanato case. And we call on all Ghanaians of every party to insist that the standard which cleared Mr. Chikese's name in 2016 be demanded with equal conviction today. Let us be clear about what this statement is not. It is not an attack on the judiciary as an institution. It is a call for consistency, for constitutional fidelity, for a justice system that inspires confidence across the political divide and not merely within it. History will not remember this moment for the length of sentence. It will remember whether Ghana, when tested, chose to defend the Constitution for everyone or only for the power of the day. We choose everyone. We choose the Constitution, and we will be judged rightly by whether we meant it.
Well, taking us to 33 minutes past 7, that's Patricia P.J., Honourable Member of Parliament, the minority, Deputy Minority Leader. She's Member of Parliament for Asokwa, right? Asokwa, okay. And reading out the minority's position, like I said, reading out the minority's position on this matter. So her job was simple. The minority had agreed what their position was. They put together a statement. She went to read it out to the public. Well, 4 things they've raised. The first one, they say, is the denial of that the court denied Chairman Wontumi, Bernard and Chibosiako, right? SM, that's the name, right? A council of choice. So a council of his choice. Okay. Because on that day, she is claiming that Atachan had written to them, Lawyer Atachan, who is also a former member of parliament, had written to them indicating that he had to attend to a prior arranged professional engagement. Atachan subsequently told us that he went for his daughter's
graduation,
which is not a professional assignment.
It's
personal.
Graduation also.
It's personal. It was not a professional assignment. Yeah. Okay, so it's personal. Then, second issue they raise is what they call piercing of the corporate veil. I think that is more of a legalistic matter, because they are saying the company must be separate from the man must be separate from the company. You must establish wrongdoing to be able to jail the man, else the company carries culpability. So how did they are not happy with how, what do they call it? The court arrived at the conclusion that Chairman Wontumi should be the one who should be ultimately held responsible. Mm-hmm. So they are not convinced that corporate veil was pierced in a manner that should arrive at the conclusion that Chairman Wontumi should be held accountable. Yeah, so I'm trying my best to tell you what she said that I remember is that the judge treated the two of them as if they are one in the same, which is not what the position of the law is. So that's the second one.
Okay.
Then they talk about selective justice.
Yes.
Selective justice there, you know what? Always there's Yamin and Abanga's name will come. You remember that thing that famously came up, and the president referred it to Yoko and everything. So they are saying that if you are prosecuting, prosecute everybody. Don't. Then the fourth one is that they sidestep the request for constitutional review. So what they were asking for is that, I think at the time the request was, and let them correct me if I'm wrong. This is Atachia goes before the court. Actually makes an application to the court, asking for the court to defer judgment because they want the court to refer portions of the Minerals and Mining Act to the Supreme Court for interpretation before the court makes a decision. Yeah. Okay, so they went before the court asking that we believe that there is something to interpret. When it comes to the Minerals and Mining Act. And this is not an automatic. So the court must be convinced that there's a question to answer, that the court cannot answer or does not have the capacity to answer, the mandate to answer. When it comes to constitutional interpretation, you usually send it to the Supreme Court. But first, what are we interpreting? You must convince the court on that. And I recall famously in the Zanatom matter, I think Edwin Tamaklo attempted twice to convince the court to refer a question to the Supreme Court. Okay, the court disagreed on both occasions. So he takes the court's decision on his request to the Supreme Court. So I come to you and I say, you should refer this thing to the Supreme Court. You disagree, you say no. There's nothing for the Supreme Court to interpret. So the decision of the court on his request, he takes it to the Supreme Court for judicial review. The Supreme Court agreed with him and was of the opinion that there was a question to answer. And so asked the trial judge to put a stop to everything that is happening and then took up the issue to interpret before the trial judge will continue. And that's where the Zanato matter ended, because the court's interpretation ultimately rendered somehow was in favor of Zanato Ajimaronix. And I remember those days, Kwale Clotier and everything. So there's no automaticity. I don't know whether there's a word like that. It is not automatic. The court must make a decision on it. It must make a pronouncement. If you don't like it, you take up that decision of the court to the Supreme Court. The Supreme Court will assess it and assess whether or not the question you are raising is germane. You cannot just come and say, I want you to refer. No, you must convince the court why there is a question for the Supreme Court to answer. A question that is not clear enough. So ambiguity, like recently we've been reading, what do they call it? Remember the constitutional provision, third term, that we're reading over and over again, trying to see if there's any ambiguity in it. Okay? And when we did that, we read it over and over again. We're of the opinion that there's nothing ambiguous about it. Mm-hmm. But somebody has still taken it to the Supreme Court. In this case, it's an ongoing trial. So if you want something referred, you must convince the court. But it seems the court was not convinced. Have you found? Yeah. Okay, so what did the judge say about that question?
So, counsel for Wontumi urged that this court stays the delivery of its judgment and should refer a number of questions to the Supreme Court under Article 132 of the Constitution 1992, namely whether Section 14.1 of Act 703 and Section 992B of Act 703 as amended and the charges in count 4 and 6 founded on Section 992B are on a true and proper interpretation of Article 1911 of the Constitution, unconstitutional for vagueness and overbreadth. The Republic resisted this submission.
Okay. I'll come to that. Please hold on.
All right.
And we'll come back to that. He will continue to go through exactly what the judge said. Yeah. But before that, let's just speak to Dr. Jonathan Asantio-Chiri, who is Executive Director, African Institute of Strategic Studies. Thank you very much for your time and good morning.